Hello everyone. Today, our topic for discussion is general defenses in criminal law. If we talk about the general defenses which are given in criminal law, then general defenses are available in relation to a range of offenses rather than those which are available only in relation to a particular crime. General defenses are those which arise from specific characteristics of the defendant or the circumstances of the offense, which mean that the prosecution cannot prove all the elements of the offense. They may result in an acquittal or they may reduce the defendant's culpability to render them guilty for a lesser offense. If we talk about the general differences through the structure of IPC, then the Indian Penal Code 1860 consists of 23 chapters, 511 sections, and the code was passed on 6th October 1860 but came into effect from 1st January 1862. The Charter Act of 1833 facilitated the emergence of this code under the stewardship of Lord T.B. Macaulay. This codified statute is a substantive general law of crimes in India and is exhaustive in respect to matters covered by it. If we move further, then we will know about the main general differences which are present in criminal law, that are automatism, intoxication, mistake, insanity, duress and necessity, and self-defense, the defense of others and of property. When a person proved with the commission of an offense and ought to have been punished by law, if he is exempted from such legal punishment under special conditions stipulated in the law, it is known as general exception. Chapter 4 of IPC deals with the general defenses in the Indian Penal Code. In fact, these provisions indicate the absence of mens rea element in the acts of commissions and omissions on the part of the perpetrator of the offense. We have already talked about the mens rea in our previous videos. When a person is accused of an offense, the burden of proving the existence of circumstances bringing the case within the exception lies on the accused person. Now for automatism. If we talk about automatism in detail, it is an act which is done in a state of automatism if it is done by the body without control by the mind. For example, it is a spasm or a reflex, or if it is done by a person who is not conscious of what they are doing. To claim a defense of automatism, the defendant has to have a total loss of control over their actions, meaning they cannot be held liable for those actions because their conduct lacks the basic requirements of being voluntary. There must be a total destruction of voluntary control on the defendant's part. If the defendant retains impaired, reduced, or partial control, the defense is not available. The defense of automatism is limited in the following circumstances. First, where automatism is caused by a disease of the mind, where automatism is caused by self-induced intoxication, where automatism is caused by a self-induced incapacity other than intoxication due to drink or drugs. Example, a failure to eat while taking insulin. Or where there is only a partial destruction of voluntary control on the defendant's part. Now, moving forward, if we talk about intoxication, then intoxication may be voluntary or involuntary and may be brought about by drink or drugs. Intoxication has the potential to remove the necessary mental element required for a defendant to commit an offense. It is not a defense as such. Intoxication can be divided into two categories: voluntary intoxication and involuntary intoxication. What does a voluntary intoxication mean? If the defendant got themselves intoxicated, then it is voluntary intoxication. And for example, where a defendant's drink has been spiked, the defendant was not responsible for becoming intoxicated. If If someone has already spiked something in the drink of the defendant and that caused intoxication, then it will be known as involuntary intoxication. The distinction between the two types of intoxication is important when considering whether the offense the defendant is alleged to have committed is one of specific or basic intent. Involuntary intoxication can be raised in answer to a charge of both specific and basic intent. Voluntary intoxication can only be raised to answer a charge to an offense of specific intent, for example, murder or theft. If we talk about intoxication in depth, then intoxication may lead to dementia affectatia, which is a state of mind equal to insanity. That is, the function of the mind is temporarily suspended. Section 85 and 86 crystallize the law relating to acts committed by a person in intoxication in mitigating the rigor of law. Voluntary drunkenness cannot be a cloak of immunity. To claim exemption from criminal liability on the grounds of involuntary drunkenness, it must be established that he was first incapable of knowing the nature of the act, or second, that he was doing what was either wrong or contrary to law, and third one, that the thing which intoxicated him was given to him without his knowledge or against his will. For example, a person committing an offense when intoxicated by fraud, coercion, or ignorance practiced by someone, then it will be involuntary intoxication. Based on the principle, one who sins when drunk should be punished when he is sober. It is given in the section 86 that if an act is an offense only when done with a particular intent or knowledge, and such act is committed by an intoxicated person, he is liable unless he can show that he was intoxicated without his knowledge and against his will. Voluntary drunken person will be liable as if he was sober when he did it. It must be considered as an aggravation rather than a defense. There are lots of cases where intoxication has been discussed, such as Sarthi versus State of MP in the year of 1976. If we talk about the case, there were 3 drunken accused who roughed up the deceased, made him unconscious, and without ascertaining whether he was dead or alive, hanged him from the ceiling fan. State of intoxication gave the accused benefit to be convicted under section 304 IPC instead of under section 302. So, moving forward on the mistake, so to raise the defense of mistake is to deny the mens rea of the particular crime charged. If someone is saying that it was done by the mistake, then he is saying that he was having no intention of doing a crime. So the defense of mistake requires the accused to have made a mistake about the circumstances or consequences of an act which nullifies a suggestion of criminal intention. A mistake about the law will generally be no defense, save where knowledge of the legal state was relevant to the requisite intent. Mistake of fact is more commonly relied on as a defense. The test is whether the accused belief was an honest and genuine one, which is very subjective. It is not relevant whether the accused mistaken belief was reasonable. This is different where the required state of mind is negligence, in which case reasonableness will be a factor, because an unreasonable mistake would be proof of the negligence, which is the basic of liability. So mistake provides no defense to strict liability offenses. In case where the criminal intention is subjective, recklessness, then the mistake will also be considered subjectively. So, moving forward, we have insanity. If we talk about insanity, we have insanity is a complete defense even to strict liability offenses. To establish a defense of insanity, it must be clearly proved that at the time of commission of the act, In question, the accused was laboring under such a defect of reason from a disease of the mind as not to know the nature and quality of the act they were doing, or if they did know it, they did not know it was wrong. In the Crown Court, a jury may return a special verdict for not guilty by reason of insanity. This is provided for in the section 2 of the Trial of Lunatics Act 1883. For a special verdict to be returned, the prosecution must prove that the accused did the act or made the omission charged. A special verdict is inapplicable to trial in magistrate court. Thus, a defense of insanity would lead to a completely acquittal in the magistrate's court, although the defendant may not necessarily be released but may instead be detained on mental health grounds. Section 84 provides exemption from criminal liability in respect of acts of a person of unsound mind, which is also known as non compos mentis. At the time of the act, incapable of knowing the nature of the act and not capable of understanding what he was doing, was either wrong or contrary to law. Therefore, there are four kinds of person with non compos mentis. First, an idiot who is of non-sane memory from his birth, perpetual infirmity without lucid intervals. Second one is illness, which leads to non compos mentis. Third is a lunatic, afflicted by mental disorder only at certain periods and vicissitudes. Lunacy and madness are acquired insanity, and idiocy is natural insanity. And the fourth point is intoxicated persons. So insanity may be divided into medical insanity and legal insanity. Indian law recognizes legal insanity. So established only if it is known that the cognitive faculties of the person are such that he did not know what he has done and what will follow his act. If we talk about insanity in Ray Bala Gopal case, husband killed wife and son, held that the plea of insanity could well be sustained by the statement of the doctor. Therefore, M. Norton rule was diminished responsibility, suffering from abnormality of mind either due to arrested or retarded development of mind, any inheritant causes or induced by disease or injury, then mental responsibility is substantially diminished. Now, moving further, if we talk about duress and necessity. So, duress by threats provide a complete defense to a charge of any offense other than murder, attempted murder, or potentially treason. The defense arises where the defendant commits the offense with the relevant intention but is induced to act by a threat made by another person, or where the defendant reasonably believes such a threat has been made to the effect that unless the defendant commits the offense with which they are charged, they or a third person will be harmed. The evidence for a defense of duress must be raised by the defendant. The burden is then on the prosecution to disprove the assertion. Necessity differs from duress in that it is not an excuse but as a choice between two evils which provides justification for the offense. The defense of necessity is available only in very narrow circumstances. Section 94 exempts a person from criminal liability in respect of an act committed under compulsion or duress, based on the principle actus ne invito, factus est nisi actus, that is, an act done by me against my will is not my act. This defense is subject to two exceptions. First, murder, and second, waging war against government of India, which is punishable with death. But English law permits a man to save his life at the expense of the state. The threat under section 94 must be of instant death to the person compelled to commit the offense. In R versus Hassan 2005 case, House of Lords held that defense of duress is not admissible when the accused voluntarily associates with other engaged in criminal activity. If we talk about R versus Hudson and R versus Taylor, charge of giving false evidence under threat of death by the other party. Trial court convicted and Court of Appeal set aside the conviction. The act of giving false evidence was under duress and threat of life. If we talk about R versus Bond, a defense to a charge of bestiality, husband compelled his wife to have carnal knowledge of a dog which was an offense. On appeal, held that wife was terrorized by husband to commit such act against her will, and defense of duress exempted her from conviction. Therefore, duress is very necessary if we talk about defense. Now, if we talk about self-defense and defense of others or property, self-defense is an absolute defense which can apply to offenses committed by force. Self-defense as a defense can take the form of defense of a person or property, the prevention of crime and the lawful arrest and apprehension of offenders. The defense will be available to a person if they honestly believed it were necessary to use force, and if the degree of force used was not disproportionate in the circumstances as the person viewed them. In determining what force is reasonable, the physical characteristics of the defendant might be relevant. When raised by the defense, it is for the prosecution to rebut a defense of self-defense to the criminal standard of proof. The factors which it may rely on include use of excessive force. Second, the consequences of the action taken, particularly where the result was death or serious injury. Third, the use of a weapon in applying force and premeditated violence. For example, going armed to exact revenge. Basically, it means if someone is using self-defense, then they should also look about the consequences of the actions which he is going to take. If someone has attacked someone with bare hands, then it is not appropriate or it is not legal to take revenge with arms or anything that will be going to give the person death or a serious injury. Now, if we talk about the defense of property, then section 103 gives that the right of private defense of property extends to the causing of death of any other harm to the assailant under the following circumstances. First is robbery. Second, housebreaking by night. Third one is mischief by fire to building, tent or vessel used as a human dwelling or for custody of property. And fourth, theft, mischief of house trespass, reasonably causing the apprehensions of death or grievous hurt. Section 104 says that the right of private defense of property extends to the causing of any harm short of death. I will repeat, extends to the causing of any harm short of death. Now, if we talk about defense of property mainly, then section 105 fixes the time when the right of private defense of property commences and when it comes to an end. The right commences as soon as the reasonable apprehensions of danger to property commences, and its continuation depends upon the nature of offences. It continues in case of first, theft till the offender retreated or procurement of assistance of public authorities or till the property is recovered. Second, robbery, as long as the offender causes or attempts to cause any person death or hurt or instant personal restraint continues. Third is criminal trespass or mischief, which we talked about it, as long as the offender continues in the commission of criminal trespass or mischief. And fourth one is housebreaking by night, as long as such house trespass that began continues. So that was all for the general defenses. Thank you so much, and do subscribe the channel for more amazing content. Thank you.